Okay, we are ready to reconvene our adjudicatory hearing at 1:20. I believe we open with Mr. No, sorry, it's your turn, right?
Yes.
You have your next witness, excuse me.
Mr. Chairman. Yes, I have Mr. Wesley Edens here as our next witness, who is prepared to address one of the three topics in the notice of adjudicatory hearing. So this may be the world's shortest direct exam. Mr. Edens, could you please speak to the committee?
Mr. Chairman, thanks for the opportunity to come and talk to you. I'm the founder, one of the founders of Fortress Investment Group. We're a money management company based in New York. Formed the company in 1998. We started with 26 employees and managed a little over $400 million in capital. Today we have just under 1,000 employees around the world and manage about $55 billion as of the end of last year. We are not directly in the gaming business. I'm in the investment business, and I run the private equity portion of our company, of which the investment in Penn Gaming is contained in one of those funds, or a couple of those funds. We have investments in a number of different sectors. We're large investors in transportation and infrastructure, healthcare, we're the largest owner, I think, of senior housing in the country, financial services, media. We actually have a very significant media presence in the state of Massachusetts. We have our company Gatehouse has ownership of about 130 local newspapers in this part of the world, and actually has part of our business based here in Boston. Our business is subject to extensive regulatory and oversight in both the United States as well as around the world. Our principal offices are based in New York City, which is where I live. We have offices in London, Frankfurt, Rome, Singapore, Shanghai, Tokyo, Sydney, so a number of different parts of the world, and have regulatory presence in all those markets. I serve as a director of Penn Gaming. In 2007, in June of 2007, we reached agreement, ourselves and a couple other folks in the investment group reached agreement to buy Penn Gaming in its totality. In the period of time between when we agreed to buy the company and when we were scheduled to close on it, there was a financial crisis, and so over the course of that 12 months, or actually more than that 12-month period, it became increasingly clear that there was a challenge to closing the transaction. We had made a commitment to Penn. We had banks that had made commitments to us to provide financing, and there was a lot of noise, as you might expect, in the summer of 2008. We reached an agreement with Penn to alter the nature of our investment, and rather than acquire the company, we made a $1.25 billion investment into preferred stock that is convertible under certain terms into the common stock. To address the question directly that Mr. McHugh asked earlier, if you, on a fully diluted basis at $67 a share, that's where it all converted, we would own 15.8% of the company. That overstates to an extent the amount of voting control we have, because we can't vote as a common shareholder. We're a preferred shareholder, and I'm simply I serve on the Penn board as a director. We have no role in the day-to-day operations of Penn Gaming, so it's just merely in my capacity as a director of the company. I've been asked in particular to provide testimony about our hiring of Dan Mudd and the subsequent departure of Dan from the firm. Dan was a director of our company at the time that we took the company public. He was well known to one of my partners, Pete Brigger, who's one of the partners who runs a big part of our business. Had done a lot of business with Dan when he was in Asia. Pete was running the principal investing group for Goldman Sachs. Dan was in charge of GE Credit's business in Southeast Asia, so they had some business dealings at that time, so they knew each other. I knew Dan very casually. I didn't know him well personally then. He was on the board of directors for us. Of course, then in 2008, in the fall of 2008, about 5 years ago, the federal government put Fannie Mae and Freddie Mac into receivership. Dan stepped down at that time. That was an extraordinary period of time. We performed our own investigation with respect to what we thought Dan's position was then, and we were satisfied that he had done nothing wrong in our opinion, based on the facts as we had them presented. He stayed on the board. Financial crisis intensified in the next year. I guess it was in. Just want to get my dates correct here. In August of 2009, we asked Dan to step in and become the CEO of the company. I was the CEO at that time. What became very clear after we took our company public is that being the CEO of the company was a job additionally or incremental to my day job of being an investor. And so we thought it was a good idea to basically focus on investing the money, which is what our primary job was, and brought Dan really in as an administrative CEO. He played no role whatsoever in any of the investment operations of the company. To my knowledge, he never sat in a single investment committee that I had or was involved in the management of the investments whatsoever. So he was really an administrative CEO, and I thought that he did a good job during the period that he was the CEO. In March of 2001, Dan received a Wells notice, which he promptly notified us about. A Wells notice is not a dispositive notice that there's going to be action taken by the SEC, nor is it something that we thought was of sufficient cause to separate ourselves from Dan. He issued a public statement that basically said what he believed to be the facts. The facts, as I understand them, is that the Wells notice that then, at the end of that year, which turned into a civil lawsuit filed by the SEC, the primary focus of it was the degree and the type of disclosure that he signed off on as CEO regarding the mortgage holdings of the company. Again, it's not my position to know how that hearing will end or not end. So Dan is in the process of dealing with his lawsuit. What I would say is that the form of the information, the disclosures that were used by Dan while he was CEO, I believe are exactly the same as what Fannie Mae uses today. So that may be.
Say that again, I'm sorry, I didn't follow that.
The disclosures that were used by Fannie Mae on their mortgage portfolio that Dan used as CEO, that they are critical of, that they now, I believe, is the subject of the civil lawsuit, pending with Dan. I believe is exactly the same form of disclosure that they have used subsequent to that up to today. So, without knowing whether they'll find that was correct or incorrect or sufficient or insufficient, it's just a matter of note that it's exactly the same as it is right now. So, but when Dan got the notice in December of 2011 that there had been a securities action filed against him, we sat down as a board. We talked about it. We decided basically that Dan needed to go and focus on the things that were pertinent to his life with regards to defending himself against the lawsuit and whatnot. We asked him to step down. He did so, and there's been really no contact since then. So Dan is a guy I personally think has tremendous integrity. He's a very straightforward character. What the result of his civil lawsuit will be years later, I don't really know. But that's basically what has been that. Good question.
Yeah, that's substantially different than the account that we've read in the investigations report, which is that the board decided not to let him go. They discussed those options, but then decided to place him on leave and wanted to discern the reaction of its investors before taking any action. And then there was negative reaction. So the board did not move on this until there was a negative reaction. Is that accurate?
The board met as soon as we got notice of the notice, and we decided to think about it and gauge what we thought were the ability for Dan to discharge his duties as CEO. The time frame involved is very short. We're talking about a matter of days, right? From the time when we actually first got the notice until Dan was put on leave and then departed the company shortly thereafter. So there's not a lengthy period between one and the other. I think the specific dates, which I can find. Dan resigned on January 24th, 2011. 12, excuse me. On December 16th, 2011 is when he got the notice. So the time frame involved in totality, including the holidays, is about a month.
But did you wait for a negative reaction from investors before making that decision?
The negative reactions from investors were one of the things that we considered, but really, as a board and individually, my view about it was that we needed to contemplate whether we thought Dan could be effective in his role as CEO, even administrative CEO, while he was actually dealing with his own lawsuit. So there's a number of things that were involved. Certainly, we had a handful of investors that contacted us and said, look, you know, what do you expect to do about Dan? And they had a negative reaction to it, but there were others that expressed support. It was not a unitary action of one investor or any series of investors. We have many thousands of investors that across the firm, and so it was really the collective judgment, I think, of all the facts that were pertinent, and we said, you know, it's the right thing. Dan resigned, you know, voluntarily, so we didn't ask him to step down, but it was certainly our judgment that he was going to have, you know, a challenge in performing his duties adequately. So.
When you say he resigned voluntarily, you didn't ask him to step down?
No, we didn't ask him to. Ask to step down would be another way of saying we fire him. We did not fire Dan. We had
You gave him an opportunity to resign then?
Yeah, we dealt with him consistent in the manner that he had performed his duties, which was, you know, in an open and transparent matter. It was the best interest of the shareholders, of which were very large shareholders, and our investors that we're most focused on. And I think that the conclusion at the end was an obvious one.
When you speak about the allegations, one of them is that he lied before Congress. That's an allegation as well. It's not just, you know, what happened with his sign-offs at Fannie Mae. So it seems to me a very serious matter, and I guess I was concerned reading that the board said, you know, no, we don't want him to step down, and let's see what the reaction is from investors before we basically...
I still believe in this country it's guilty, or it's innocent until proven guilty, and so people can allege whatever they want to allege, including the government. We base our views about Dan based on our own interactions with him and based on the facts and circumstances that we deal with him, just as I would with anybody, as I would with you or any other person I worked with or dealt with in business. Dan had always discharged himself honorably in a manner consistent with the professionalism we expect in our organization. And so we took what we think was a reasonable and prudent course of action to consider it, not do anything in a hasty manner, and then deal with it subsequently. So, you know, I think that you know, the story is not completed in terms of how that lawsuit will be resolved. Those were extraordinary periods of time. There was an allegation of lying. There's allegations of lots of different things. I can only speak to what my own interactions with him were, which were nothing but professional and with a lot of integrity, and that's what we did. But even given that, our view was, and eventually Dan's view as well, is that he needed to go and focus on his own issues in dealing with that lawsuit. It was inconsistent for him to be the CEO of our public company. So.
Mr. Mackey, do you want to, are you finished?
If I may.
Oh, sure, please,
I
go
think
ahead.
I may save Mr. Mackey some time by clarifying
Sure.
one point before I turn the witness over. I want to distinguish between two sets of dates, Mr. Edens. And for the commission's benefit, the applicant's hearing exhibits, 10A is an SEC filing made by Fortress in March of 2000. I'm sorry, forgive me. There are two SEC filings, 10A and 10B, both 8K filings by Fortress. Mr. Edens, here's just to clarify, I wanted to distinguish the time period of the Wells notice on the one hand, and the time period of the SEC action on the other hand. So, and if one were to read from what's now been admitted, 10A, the Fortress filing, says that on March 11, 2011, the staff of the U.S. Securities and Exchange Commission, the SEC, notified a so-called Wells notice, counsel for the chief executive officer, Mr. Daniel Mudd, that it is recommending that the SEC commence a civil enforcement action against him, etc. And then it concludes by saying, under SEC rules, Mr. Mudd is permitted to make a Wells submission in which he seeks to persuade the SEC that no such action should be commenced. Mr. Mudd has informed the company that he intends to make such a submission. My simple question to you, Mr. Edens, is Does that refresh your memory that the Wells notice that Mr. Mudd received was in or about early March of 2011?
That's correct.
And the company Fortress made a public disclosure of Mr. Mudd's receipt of that Wells notice.
We did.
Okay, now, just quickly, we can turn to 10B, which is a subsequent 8K filing. And 10B reads in part, on December 16, 2011, the SEC filed a civil complaint in the Southern District of New York against Mr. Mudd. Then it proceeds. Does that refresh your memory that the civil complaint, the SEC action, was in or about December of 2000?
December 16th.
All right. And,
And then, not to interject, but Dan was placed on administrative leave on the 21st of December. So the time frame of actual, causative action, as it were, between when Dan received the lawsuit and when he actually went on administrative leave was a very short period of time. He then resigned on January 24th. So I think we dealt with it.
and the last document I'd like to refer to is IEB's Exhibit 17, which is a copy of Mr. Mudd's severance agreement. And I would point to, if I may, two portions of Exhibit 17. First, for the benefit of the Commission, on the first page of Exhibit 17, Section 1B states in part, you agree to sign the resignation letter set forth in the form attached here to as Exhibit A. And then three other points, which I believe there has been some confusion on, that the severance agreement, I think, clarifies. You agree to execute any and all documentation provided to you by the company or any affiliate relating to I, the relinquishing effective as of December 21, 2011, of any and all signing authority you may have on behalf of or with respect to the company or any affiliate, including, for the avoidance of doubt, any funds, etc. Subsection 2, your resignation from the office of Chief Executive Officer, effective as of January 24, 2012. And 3, your resignation as a board and management committee member, effective as of December 21, 2011. Mr. Edens, can you confirm, please, that the date of Mr. Mudd's resignation from management was effective essentially immediately upon the signing of his severance agreement? Is that fair?
That's correct.
And was there,
Although he was suspended essentially with, administratively 5 days after we received the SEC notice, which actually predates the actual resignation by about a month.
and for the Commission's benefit, Section 1 on that same page of Exhibit 17 sets out a third status that from which Mr. Mudd resigned as an employee. The date of his resignation as an employee, do you recall whether that was some 30 days after?
Yeah, February 22nd.
Okay, so, and do you know why the effective date of his resignation as chairman from strike that out, please. Do you know why the effective date of his resignation from management was immediate, while his effective date of leaving as an employee?
I think
It
it
was 30
was,
days
I think it
out.
was administrative, maybe getting subsequent health care for his family or something like that. I don't recall, actually.
And
I mean, from a practical standpoint, when he was put on administrative leave, and 5 days after we got the notice, that kind of ended his day-to-day involvement with the company, so.
And the last thing I'll point to for the Commission's benefit, the last page of Exhibit 17 of the board exhibits is a copy of Mr. Mudd's brief statement of resignation, which if I may, it is very brief. Effective January 23, 2012, I hereby resign from any and all positions with Fortress Investment Group LLC, with any of its affiliates, and with any of their respective funds. Last sentence, in addition, effective February 22, 2012, I hereby resign from my employment with FIG LLC and with any of its affiliates. And that's the last page of Exhibit 17. I have nothing else I'd like to ask this witness.
Mr. Mackey?
Okay. Mr. Edens, good afternoon. I just want to set the time frame again so it's clear in the Commission's mind. Prior to August 2009, you were both the chair of Fortress and also the CEO of Fortress, holding both roles. And at that time, August 2009, Mr. Mudd was serving as a director of Fortress.
From the time I took the company public in February 2007, so.
Okay, all right, right from the start then. And you said
Excuse me, not right from the start. We formed the company in 1998.
but from the time it went public,
From the
in
time it went
2007,
public.
Mr.
That's
Mudd
right.
was one of the original directors.
That's correct.
Okay. And you testified that did you know him at all before February 2007 when he came on the board?
I'd met him a handful of times, but I was not close personal friends with him. I knew him in his capacity at Fannie Mae a little bit. Maybe I'd met with him once or twice there.
Okay.
One of my other partners had spent a lot of time with him. But
Okay, this is Peter Brigger.
Brigger.
Brigger?
Brigger. Yeah.
Would you characterize him as a close friend of Mr. Brigger's?
I don't know if he's a close friend. He was certainly a business acquaintance with him, so he had some dealings with him.
Okay. Now, as of the time that Mr. Mudd became one of your original directors after going public, you were aware that he was also serving as the CEO of Fannie Mae at
That's
that time?
correct.
Okay. So then, fast forwarding up to the fall of 2008, and you had a little bit of testimony about that, the financial crisis that took place then. You're aware that in September of 2008, the Federal Housing Finance Agency placed Fannie Mae into receivership.
That's correct.
Okay. I want to, do you have the Bureau exhibits in front of you? Exhibit number 18, which is a copy of two newspaper stories, one from the New York Times, one from the Wall Street Journal. Represent for the record that the first article is a New York Times article from September 7th, 2008, entitled "Few Stand to Gain on This Bailout and Many Lose." Could I ask you to turn to the second page of the article?
Sure.
Okay. I guess first of all I should ask you, do you recall reading this article when it came out?
I don't.
Okay.
There were probably literally thousands of articles written about the bailout.
Yeah, no, I agree. With a Google search, you could come up with a million. 5 paragraphs down on the second page, this paragraph beginning with the shareholders, do you see that?
Uh-huh.
Okay. The shareholders of Fannie Mae and Freddie Mac, including many employees, will not be so lucky. The company's share prices have plunged about 90% this year, wiping out about $70 billion of shareholder value. The shares are likely to be worth little or nothing under the government's rescue plan. Did I read that correctly?
Yeah.
Okay. Do you, as of September 7th, 2008, were you generally aware of the extent of the collapse of Fannie Mae and the loss of shareholder value associated with that?
Absolutely.
Okay. Then turn to the last page of Exhibit 18, if you could, which is an article from the Wall Street Journal. And the headline on this particular piece by Michael Crittenden is "Cornine Seeks Criminal Inquiry of Fannie Freddie Executives." Do you recall this article, seeing this article at the time?
I don't.
If you recall, do you recall ever seeing this article?
I don't.
Okay. Were you aware in approximately September 2008 that there were political leaders in the United States asking for a criminal investigation of the senior leadership at Fannie Mae?
There were political leaders then, there are political leaders now that believe there should be a lot of criminal investigations, both at Fannie Mae, Freddie Mac, banking groups, a whole host of folks. So I don't remember anything particular about Fannie and Freddie, but
So the question is, were you generally aware in September 2008 that there were people calling for criminal prosecution stemming out of Fannie Mae's collapse?
I guess I don't recall.
Okay. You were aware, presumably, again, the September 2008 timeframe, that in the midst of this complete collapse of Fannie Mae, the FHFA removed Mr. Mudd as CEO.
I believe what happened is they put the company into receivership, just like they did Freddie Mac, and they asked for the senior management of both of the companies to resign.
Right, correct, okay.
That receivership, by the way, is actually currently being adjudicated. It's a pretty lively topic right now, if you're aware of that. Right, I mean, the legality that the shares of Fannie Mae and Freddie Mac have actually rallied fairly substantially, the preferred shares. There's a question as to whether or not the receivership that they put in place at the end, as I understand it, I'm not involved in this, I'm just reporting what it is. Like there's even today, there's a fair bit of dispute over exactly how that transpired and how it's going to turn out. The preferred shares have risen many multiples in value in the last 6 months as this lawsuit moves ahead.
So, based on the events that we've just discussed, which were, the complete financial collapse and receivership of Fannie Mae, the calls for legal action against senior executives at both, Mr. Mudd's removal as CEO of President, did you have any concerns as chair about Mr. Mudd's continued service on the Fortress board?
Did not.
And why was that?
Because I didn't have any concerns about it. I didn't think that he was, Dan was the CEO of a company that buys and insures mortgages. The residential housing market in the United States of America went down about 30-odd% in the totality. It's something that is unprecedented. In my opinion, it wouldn't matter who was running that company at the time. There would have been a complete collapse of it, just given the financial structure of it and the exposure they had to the housing market. And so, and furthermore, I didn't think that Dan personally played a role in causing Fannie Mae to collapse. That was not my opinion at the time. It's not my opinion today.
What about, while we're on the subject, his role in the loss of shareholder value in the company by about $70 billion?
Dan was the CEO of a company who that essentially was taken over by the government, so there was a complete loss on it. I think his responsibility as the CEO is in part responsible for that. I do think, though, that the market forces of the housing market collapsing had an awful lot to do with the eventual collapse of the company. As I said, I don't think that actually it would matter who ran the company at that point in time. If the housing market went down 30-odd% and you insure or own a bunch of mortgages, I think that there's going to be enormous declines in value, just as there is.
But if you owned a whole lot of subprime mortgages, it wouldn't necessarily have gone down if you owned healthy mortgages.
Healthy mortgages went straight down too. I mean, the declines on both sides were historic. If you look back, going back to housing prices all the way back to the Great Depression, there was only very brief periods of time when you had very isolated parts of the country that had those kinds of declines. Places that had real concentrations in single industries, like Texas in the mid-1980s when the oil prices really collapsed. There was nobody, to my knowledge, and I've been around the mortgage business professionally my whole life, professional life, that had any view whatsoever that you would have this kind of collapse, whole scale across it. Because with a 35% decline in housing prices, which is approximately the number I think that people use in the industry, prime mortgages would perhaps be less hurt, but a prime mortgage portfolio suffered tremendous losses as well. So the subprime stuff was clearly the most affected, and they had exposure to that, as it turns out. I think that's the dispute as to what the nature of the disclosure is. Again, I didn't create the disclosure. The only thing I would make as a point is that the disclosure that Dan used, if you go back, there's actually testimony in front of the House from those periods of time when he became CEO, commending him on the type of disclosure that he was using. So, 20/20 hindsight, could they have disclosed it differently? I guess the answer is sure. But with the financial leverage that Fannie Mae and Freddie Mac operated at, I think it is likely that they would have gone out of business had they had an entirely prime portfolio. That's how severe the downturn was. The subprime stuff obviously was most previously impacted, but you know, the prime stuff would have gone down as well. It did go down as well.
September 2008, Fannie Mae goes into receivership, completely financially collapses, and there are calls for legal action against the senior executives at Fannie Mae. Less than a year later, Fortress hires him as their CEO, correct?
Yep.
Okay. And you were asked in the course of the suitability investigation about his hiring. Do you recall that?
I don't recall.
Okay.
I'm happy to.
Page 103 of the report. I think it's.
Just because Smith needed it too, so just
Okay.
be careful.
All right.
Smith needed a lot as well.
Okay. Do you see the paragraph on page 103? This is page 103 of the investigative report. It says, Eden said he believed that Mudd's background in the financial sector made him well suited for the position. Did I read that sentence correctly?
Yeah.
Okay. You testified a few minutes ago that it was not so much financial acumen that drew you to Mr. Mudd, but administrative skills as CEO, running a big company as an administrative CEO?
Yes.
Okay. So what was it about background in the financial sector that made him attractive to
He had been
you?
an investor on behalf of GE prior to his time at Fannie Mae, and had been an investor running their investment processes in Southeast Asia during the Asian collapse in the late 1990s. And so he had been around those markets before as an investor. That's where Pete had met him originally. You know, GE is a fine company. Their credit culture, their processes are actually impeccable. Dan had become the administrative officer of Fannie Mae, which is a very large Fortune 500 company, and so we thought that he had a lot of skills with regards to, you know, the management of a large public company, and had a background in investing. It was not his primary responsibility to be an investor for us, and so he did not participate in my investments or in Pete's investments in any way, shape, or form.
Okay. Let me just read the rest of the paragraph. He advised investigators, that's you
Yeah.
talking to investigators, that Mudd's forced departure from Fannie Mae should not be considered as an impediment to hiring him as the CEO of Fortress. Would that be a fair summary of your statement to the
Yeah.
investigators? Okay. Why not? Why shouldn't the collapse of the company at which he was at the helm in the fairly spectacular fashion that it did collapse not be held against him in connection with hiring of as CEO of a major financial
It
concern?
was our judgment, and it was my judgment as well, that his skill set and background and acumen were well suited to what we needed at the time, and I did not hold him personally responsible for the collapse of Fannie Mae.
Okay.
I
Before,
mean, it's worth noting that one of the reasons why there's such a lively debate over the nature of the receivership right now is that Fannie Mae is now reaping spectacular profits. I would argue that a big part of the reason why they had spectacular losses were events outside their control, the collapse of the housing market. A big part of the reason why they're realizing spectacular profits right now is the opposite, that housing prices have rebounded substantially. So, I mean, I think, so the question as to whether or not was Dan responsible solely for the decline, or primarily for the decline in Fannie Mae? In my opinion, no. But it's just my opinion, so.
I would also probably note that a big reason of the success is relative to now the explicit backing of the U.S. government. Is that correct?
I don't believe so. I mean, if you want my opinion as to the recent
Yeah.
success, I think a big part of their success recently is that they have raised the price by which they guarantee mortgages fairly dramatically. There's a general lack of competition because the financial crisis took out so many other people they competed with. So their guarantor fees that they charge to support mortgages have gone up, you know, 3 or 4 or 5-fold. They've gone up very substantially, and housing prices have gone forward. Those two things together are very powerful impacts on the increase in profitability of Fannie Mae right now. But they're still, I mean, I'm not the expert as to what should happen with them and how they should be structured and whatever, but just to make the observation that if you're very, very leveraged to changes in housing prices and it goes down, that's a bad thing. If it goes up, it's a very good thing. And I don't think that any one individual is really solely responsible for that, and I didn't think Dan was in this case.
Who, was it the board that made the decision to hire Mr. Mudd?
It was a board decision.
Describe to me the due diligence process involved with that hiring.
Well, we have a background, checks and investigations that we run as an ordinary course with all the people that we do business with, as well as people that are on the board. And so there was again, we knew Dan as a board member. We actually conducted a series of investigations incremental to that, as we would have with any person that was of seniority that we would either do business or hire. And he passed those and to our satisfaction. And so there
Okay. Who does that background check? Is that someone internal at Fortress, or do you have an outside investigatory concern?
Both. We use investigation groups at time. We have our own. We have a very deep compliance culture. Again, we're a heavily regulated institution, so we have a lot of internal folks that do that as well.
Okay, so with respect to Mr. Mudd's hiring as CEO, it's your testimony that there was both internal due diligence done and due diligence performed by an outside investigative service for you.
I don't remember exactly what we did with the external firms.
Okay.
I would need to find out.
Is it possible there was no external due diligence done?
It's possible, but it's unlikely.
Okay. And you say it's unlikely just because it was your practice to do it?
It's our practice to investigate, people's behavior and activities in prior, relationships.
But you don't have a specific recollection of having an outside firm do it in connection with Mr. Mudd?
I don't have a recollection of that.
Okay. Did members of the board interview Mr. Mudd before he was hired?
I don't recall them specifically interviewing. He would have been on the board, since the beginning, so they would have known him well. And there was a lot of discussion about hiring Dan as the CEO, both individually and collectively. But I don't know if there was a specific, discrete interview process incremental to that.
Okay. Did anybody on the board, or did you, Mr. Edens, have a specific discussion with Mr. Mudd about potential legal fallout from the collapse of Fannie Mae?
I don't recall having that. I didn't have that discussion with him, or I don't recall having the discussion with him, nor am I aware of it.
You did say previously that you were generally aware that there were people who were calling for legal action to be taken.
There are generally people calling for legal action today, if you read the newspapers. So I think anytime you have the kind of collapse in shareholder value and hardships that people have suffered, there's a lot of people that are still very unhappy about what has happened and want to get to the bottom of it. So that's the nature of it.
Let me ask you this: did anybody on the Fortress board, anybody involved with the hiring of Mr. Mudd, at any point say, something like, "Gee, he's a terrifically capable guy and a smart guy, but it just didn't go so well at Fannie Mae there at the end. I'm not sure he's the right guy to lead our organization." Did anybody suggest that?
I don't think so. I mean, not to my knowledge. I think when you look at that period of time and what was going on in the world, which is a remarkable period of time, if you disqualified for consideration everybody who would have any involvement with the financial institution, you would narrow down the list of candidates dramatically in terms of people who would be qualified to do it. Right?
You're creating a straw man that nobody's talking about. We're talking about the guy who was the CEO of Fannie Mae.
Yep.
That's not just anybody involved in the financial world. We're talking about the guy who was the CEO of Fannie Mae. And nobody raised a question saying, do you think maybe this doesn't make sense for our company?
Fannie Mae, until the financial crisis, in my opinion, was a highly thought of and respected institution. People thought that they did their job well. With the benefit of 20/20 hindsight, when you look at what has happened in the collapse of the housing market, you can reach different conclusions. But I've done business with Fannie Mae and Freddie Mac and Ginnie Mae for decades. And I would say, in general, up until the financial crisis, they were thought of as a very well-respected, very well-run organization. That really was my perspective. Obviously,
So was Lehman Brothers, right? So that doesn't get us very far.
Yeah, I worked at Lehman Brothers too, so there you have it.
That's my point.
I thought it was a pretty good place when I worked there, but I left there a long time ago. I think that the degree of leverage in hindsight in the financial markets was way too high. I think that and that led to bad behavior on lots of different levels. I would say if you really peel back the housing market, in my opinion, there were certainly bad things that happened at banks. There were bad things that happened at brokers. There were bad things that happened with borrowers. The list of people who did wrong things is a very, very, very long list. And of course, the people at the top of the organizations are the ones that deserve the most scrutiny because they've got the most significant roles in that. But again, in my opinion, I don't think that that anybody in the position of being the CEO of Fannie Mae or Freddie Mac going into the financial crisis could have had a meaningfully different impact. I really don't. The institutions were just too big and too leveraged into a marketplace that was going down very dramatically. So, and that's what we thought about and talked about when we looked at Dan. So then we evaluated the character of Dan as an individual. Dan was a Marine Corps lieutenant. He was a guy of great integrity. He served with General Electric in what I think is a very admirable way, a high-quality company. My interactions with him were actually very, very good. He was not and is not a close personal friend of mine, so this is really, the one thing that was done completely at arm's length, and I thought at the time it was a good decision. Even when we got the Wells notice, right, and Wells notices are very, very serious matters. I would say that a Wells notice today is different than a Wells notice perhaps was 10 years ago, just because there's so many Wells notices that were issued at the time of the financial crisis. Typically, we would find that a Wells notice would lead to either charges or not charges in a lawsuit within 6 months. That wasn't the case with Dan. We got a Wells notice in March. He got his lawsuit delivered to him in December. Once it became clear that it was not just a Wells notice, but it was actually a civil lawsuit by the SEC, we took actions, I think very expeditiously. So that's.
Well, let me ask you just about the Wells notice now that we're on that. March 2011, you learned that he receives a Wells letter. Did Mr. Mudd communicate that to the board?
He did.
Okay. And your counsel has shown the commission Exhibit 10, which is the 8K filing that was done in connection with your CEO's receipt of the Wells notice.
Yep.
Did you ever see the notice?
I did not.
Okay. Did you ask Mr. Mudd for it?
I did not.
Okay. Do you know if anybody in the company saw it?
Certainly our general counsel did. I'm sure that people within the company looked at it, I'm assuming, but I did not personally.
Okay. So you think somebody did ask for it and somebody
I'm quite
took
sure
the time to
someone
look at
did.
it? Okay. Did you personally discuss it with Mr. Mudd?
I don't recall actually personally discussing it.
Do you know if anybody on the board discussed it with Mr. Mudd?
Again, I'd be speculating, but I would assume that some people talked to him about it. It was a topic of discussion at the board, of course. So we had dialogue, about it, but I don't recall actually talking to him about
Okay.
it.
It's actually, it says in the report, it says, Spectrum reviewed the minutes of the Board of Directors regarding this matter, the Wells letter. During our Ohio investigation, it was readily apparent that no formal discussions among the board members occurred following the issuance of the Wells letter. No formal discussions.
No formal discussions. The one thing I will say is that the shareholders of the company, the top 5 shareholders, of which I'm one of them, constitute about 60% of the shareholdings. We have discussions about the company all the time, and we do, not outside of the board, but we do have discussions all the time. So it could be accurate that we may not have talked about it in a formal board meeting, but we certainly talked about Dan as well as notice actively, and we care about it deeply for the biggest shareholders.
At the point where you or the other members of the board learned that Mr. Mudd received a Wells letter, did you or any member of the board direct that a more specific investigation be done of the potential charges that were facing Mr. Mudd?
We didn't know what potential charges there were facing Mr. Mudd.
Okay, but he certainly did.
I don't know what he knew or didn't know.
Okay. Did you ever ask Mr. Mudd, gee, what is the SEC after here? What are they going to charge you with?
It was very clear in my discussions with Dan early on that it centered around the adequacy of the disclosure at Fannie Mae of their mortgage holdings. It's ironic to me, for what it's worth. Dan is one of the most conservative people I have met in a public company with regards to disclosure. And he was consistently like that. His behavior with us as a public company was extremely conservative. And so it is ironic to me that that is the basis. I think it's the foundation of what they are, alleging that he did incorrectly. My own interactions with him were 180 degrees the opposite. So again, I can only base it on what my interactions were.
Okay. But if you understood that the SEC was reviewing the adequacy of the disclosures he made, and in particular the adequacy of the disclosures he made about Fannie Mae's exposure to subprime mortgages, did you or anyone at the company after the receipt of the Wells letter direct that some investigation be done regarding the adequacy of the disclosure?
I didn't direct anyone to do it.
Okay. And are you aware that anyone else did?
I'm not aware.
Okay. Did Mr. Mudd submit a response to the Wells letter?
I believe he did.
Okay. Did he show it to you?
Didn't show it to me.
Did he show it to any member of the board?
I don't know.
Okay. Do you know if he showed it to any member of the company?
I don't know. I mean, it's possible he did too.
Did anybody ask him for it?
I don't know if anyone, I didn't ask him for it. I know that
Why?
Dan made a public statement that he thought that the charges were baseless and lacked foundation, and he vigorously opposed them and disagreed with them. And that's what I know.
But weren't you and the board curious about your CEO's formal response to the SEC's fraud charges?
We're curious about it. We were very supportive of Dan as a member of the board. We were very supportive that Dan did not believe that he actually was inadequate in his representations. And so while it was a Wells notice, it was not yet a lawsuit proceeding by the SEC.
You said you believe that there was nothing inadequate about his representations. You mean nothing inadequate about the disclosures he'd made?
I'm not speaking to the disclosures. I'm not really not in a position to opine on that. I don't know. I mean, whether or not he disclosed properly or improperly with respect to Fannie Mae is left to, court of law to judge. It's not my place to judge it.
So, from the submission, from the time the Wells letter was submitted, nothing really happens vis-a-vis Mr. Mudd and his employment at Fortress until December 2011.
That's correct.
Okay. If you could, Mr. Edens, look at Bureau Exhibit number 16, that's the complaint. Do you have the document in front of you?
I do.
Okay. Do you know what it is?
I can read that it's a United States Securities and Exchange Commission plaintiff versus Daniel Mudd, Enrico Bellavecchio, and Thomas Wan. It's a complaint.
Okay. Have you ever seen it before?
I don't believe so.
Okay. So when Mr. Mudd received the complaint in middle of December 2011, did he tell you that he'd been served with it?
Immediately.
Okay. But you didn't ask him for a copy?
I didn't ask him for a
Did
copy.
any member of the board ask him for a copy?
I don't know if any other member did. Or
Did anybody in the company ask him for
I
it?
don't know. I would guess yes, but it's a guess. I don't know.
Well, did you understand what the charges in the complaint were?
As I understand them, as he represented them to us, and as our general counsel represented them to us, which were charges largely based, as I've said a number of times, stemming from the adequacy or inadequacy of the disclosure by the CEO.
Right, specifically, the complaint was that he made false and misleading statements of material facts regarding Fannie Mae's exposure to the subprime market. Do you understand that?
That would be disclosure, yeah.
Okay, and that that violated the anti-fraud provisions of the Securities Acts.
Yeah,
Okay, and that he lied to Congress about it.
that's the allegation.
But you understood at the time that was the allegation.
I did understand that was the allegation.
The suitability report. Commissioner Cameron asked you a series of questions about the board's ultimate decision to part ways with Mr. Mudd. And if I could draw your attention to page 104 of the suitability report. Do you have that in front of you?
Give me a second. Okay.
I just want the record to be clear about this particular issue. So it's page 104, the second full paragraph, the sentence beginning, "at that time." Do you see that?
Yeah.
Okay. It says, "At that time, the board considered different options, including his forced termination, but decided to place him on a leave of absence." So was it clear at the time Mr. Mudd received the complaint that one way or another he was going to leave, or was actually staying with the company one of the options that was considered?
Well, the fact is that from the time that he received the notice until he was placed on administrative leave was a total of 5 days, which I think included a weekend. Right, so you're talking about an extremely brief period of time. So I'd say that in a very short period of time, it was our determination that regardless of the ultimate adjudication of the facts regarding the lawsuit, without speaking to the merits or the lack of merits thereof, that we didn't think that it was possible for him to be an effective CEO of our company. Or of a
Okay.
public company
So,
with a lot of
okay, so
investors.
he was put on leave on December, would have been December 21st, okay.
Yeah.
And from that point going forward, it's your testimony that staying wasn't an option. It was either a forced termination or a resignation or something, but it was something that didn't involve him staying with the company.
When we put him on leave, it was not dispositive that we were going to part ways. It was the right thing to do to basically put him on leave, take pause, assess the facts, and then deal with it adequately.
Okay,
So-
so when you say take pause and assess the facts, was there a chance, notwithstanding the SEC complaint, that he would stay? That he would be able to explain the circumstances sufficiently to the board's satisfaction that he would weather the storm and stay on as CEO of Fortress?
Not a very probable chance in my recollection of it.
If you could turn to Bureau Exhibit 17, which is the severance agreement that your counsel asked you about earlier. So, do you have that in front of you? Okay. Paragraph 1A, your employment with the company will terminate due to your voluntary resignation effective on February 23rd.
Yeah.
Do you see that?
Uh-huh.
And then beginning the period of January 24th, it appears that he, beginning on that date, would not have any access to company emails, not really have any responsibilities, and frankly, not even be expected to report to the company's offices.
Yeah.
So for all intents and purposes, he was gone as of January 24th.
Correct.
But the company did make the determination to pay him through the termination date, which is February 23rd.
Yeah.
So one more month of pay.
Yeah.
Okay. Paragraph 2A, which is on the top of the second page of the agreement.
Uh-huh.
As consideration for entering into this agreement, the company will make a cash lump sum payment to you, Mr. Mudd, in the amount of $1,250,000. Do you see that?
I do.
And then paragraph 2B is reference to several million restricted share units. Do you see that?
I do.
Okay. And it references, if I'm reading this correctly, that when he signed on, he received a grant of approximately $7.2 million restricted share units, which would vest contingent on his staying employed with the company.
That's correct.
But as it turned out, he didn't stay on very long, so he only invested in 1.8 million of the restricted share units. Is that fair to say?
Yeah. I believe so. I don't know
Okay.
the exact numbers, but his initial employment contract, I believe, had a vesting schedule of 10 years. And so he was basically vesting in them ratably as he was continually employed.
But he still had a long way to go to vest in the remaining restricted share units.
That's correct.
Okay. And then, do you see 1, 2, 3, 4, 5, 6 lines down, the sentence beginning "as further consideration"?
Yep.
As further consideration for entering into this agreement, the company hereby agrees to waive the continuing employment requirements associated with the vesting of the unvested portion of the sign-on RSUs. Do you see that?
Yep.
So the company, in effect, deemed him vested in the remainder of the $7.2 million restricted share units.
Yep.
Okay. And that allowed him, in effect, to be vested in an additional 5.4 million shares of Fortress stock.
Yep.
And the total option package to Mr. Mudd at the time he was severed And it sounds like at the time the board had made a decision, there pretty much wasn't any way he was ever staying with the company anymore, was worth about $14 million. Is that correct?
That sounds correct.
Okay. No further questions.
Commissioners?
I have no questions.
Anybody? It puzzles me, I have to say, that nobody's saying that he's the guy who's responsible. Who knows and lots of people were responsible, but it was a catastrophe of which Fannie Mae was one of the central elements. People were losing everything all across the country. And you, as you said, are in a highly regulated bunch of businesses. You're a highly regulated company nationally and internationally. You're a significant player, and we're almost a very significant player in the gaming industry, which is regulated as anything. The fact that nobody would say to you, I don't really think we need this, you know, I don't know what he did or didn't do, but there's a lot of people out here who could fulfill this function. Nobody said to you, you said you're a very compliance-centered culture.
Yep.
There's no compliance officer that said to you, this just doesn't look right, I'm sorry, we just cannot do this. That nobody had a concern about that. You clearly had no concern about it. That nobody had a concern about is astonishing to me. And then to give the guy a $14 million, whatever it was, bonus for when he gets a charge for defrauding the SEC again, and nobody said to you, why would we give him an extra $14 million? He's being severed from our company because he's being sued for defrauding the people of the country. I mean, it worries me about your culture, and the culture of the company on whose board you sit, about which we are now talking. Is there anybody around there who's willing to ask hard questions and say, wait a second, this makes no sense?
Well, if the culture of believing people are innocent until proven guilty is our culture, and that's a problem, then I'm guilty. I don't believe, based on my interaction, I believe that what I'm supposed to do in the conduct of business and how I deal with people is to base my opinions of them on the basis of the interactions that I have with them and the facts and circumstances I deal with them in that context. I'm sorry, but with respect to the second question about what we should do, Dan was charged by the SEC. That will either come to pass to be something that he was guilty of or he was not guilty of. All I can say is that when we made the decision to part ways with Dan, we didn't think that merely the act of being charged with being guilty was sufficient then to treat him dishonorably, terminate him without cause, and really trying to cause him financial harm. He's been financially harmed. He doesn't have a job right now. It was very clear that the process that was going to happen with the SEC was going to take a long period of time. And so what we did, and it included me, is we did what we thought was the honorable thing, actually, of trying to do what was appropriate economically. It's not a good economic result for us to pay somebody a great sum of money when they're no longer working for us. So it was not something we did because we wanted to give him money or gift him something or try and advantage him in any way, shape, or form. But we did it because we thought that actually it was the honorable and correct way of doing so. So it was not, it was the opposite of doing something dishonorable, in my opinion. With respect to the first question as to whether or not, we talked about whether Dan would be an appropriate person to be the CEO of our company. We weighed all the facts. His past was known to us. His past predating Fannie Mae, his past in terms of the interactions it had with, my other partner in particular. We run a big and challenging and complicated business that is a global business, and we felt like he was the best person that we could get at that point in time to help us to manage our business administratively. That was, in hindsight, I understand that with the benefit of hindsight, could we have done things differently? I wish I had done things differently? I guess, but the reality is you can't change what you had for breakfast. That's the decision that was made at the time. All I can say is that we dealt with the facts and circumstances expeditiously when they were served to us, and I think that in hindsight we did the right thing with Dan when we dealt with it. So, and I think with respect to the culture of the company, I think that We manage, many billions of dollars for institutions all over the world. We're regulated by the SEC. We're a public company. If you want to read about our company, anybody can go on to the Edgar filings and look at about a lot of different stuff about us. So I think we have the most compliance-rich and reputationally rich culture that I can imagine. And I don't think that actually having Dan Mudd as our CEO in any way distinguishes us as some person of bad character. I really don't.
Well, you had to get rid of him. I mean, you had to get rid of him.
We had to do what we thought was the right interest for both our shareholders and the institutions.
Correct. And, I mean, in retrospect, the decision that you made, without anybody questioning it, to hire him was a mistake, right? Nobody came to you and said, who knows, where there's smoke, there's often fire, maybe he's clean, maybe he's not, this could totally blow up in our face. Nobody came to you and said that. Had they would have in retrospect been right.
It was our responsibility, including mine, to make the decision.
I appreciate that. And
so we made that decision, and if I could do it over again, and we knew that he was going to be charged by the SEC, we clearly would have made a different decision. We really didn't believe that he would be. That's the facts.
But the question that I'm getting at, and I made this distinction with Mr. Snyder, and it's hard to separate between the individual who you deal with as a human being, which you were with Mr. Mudd, and with the institutional issues that are in play. There are issues of appearance which are beyond substance, which do matter, number one. And number two is that there is an issue of having a culture where people aren't afraid to be skunks at the garden party, who aren't afraid to ask the hard questions that might get their butts kicked by people like you. And I'm not sure about Penn National, whether Penn National has people around there who are willing to be skunks at the garden party and ask the kind of questions that people don't like to ask. And this is this is an extrapolation, I grant you, but I see this as potentially a pattern.
I'll say this, I don't run Penn National. I have nothing to do with the day-to-day management of the company. I'm an investor in it. It's the only board that I serve on of a number of public boards where I'm not actually a majority shareholder or a very large shareholder in the company. We're a large shareholder. We're about 15% of the company, but we're not a 60 or 70 or 80% shareholder as we are in many other public companies. This is the best board that I serve on. The best board in the context for how they manage the company. I think that Peter Carlino, you're going to meet tomorrow, I guess, is an extraordinary businessman and also a leader. It is without a doubt the best board that I'm on, and I say that at every level. I think that they make very difficult decisions. They've run a great business. They conducted themselves very well during a very difficult time during the downturn, and I think they have been a great partner to communities when you look at factually how it has all transpired. I mean, so again, I can only base it on my own interactions, but if you asking me for my opinion, which maybe you are, maybe you're not, about what I think about the quality of the company, I think it's a spectacular company. I really do. I think it's actually it's very, very compliance rich. The gaming business, when you go to sign to get to licensed as a gamer, I signed documents that are probably 3 or 4 times like the thickness of this. There's a tremendous amount of background investigations that goes on, and appropriately so, given the nature of the business. But in my experience, in every other business we're involved with, these guys stand above the crowd in terms of their compliance culture and how seriously they take their job. They really do. So,
were you a part of the decision to hire Mr. Donahue as the Chief Compliance Officer?
I was not.
Were you aware of that going on at the time? Were you aware of the circumstances of it?
But I was not aware. I was not a part of it. I'm on the
But
board.
I mean, you were aware of who he was, what his background was, where he came from?
Generally, I don't remember being really specifically in it. So, but I think it's, I know this is a hearing in part to talk about kind of both the ethics and integrity, and I understand that appearances matter, and I understand that substance matters, and how they conduct themselves has been, in my experience, exemplary. So, and I'm very happy to be on the board of the company. I really am. So.
Okay. Anybody else? Either direction, counselor?
No, from here.
Thank you, Mr. Edens.
Right. Thank you very
Thank
much.
you.
Thank you.
I appreciate it. Thanks.
Let's see, it's 2:20. Yeah, let's have a quick exercise break. If it's possible, we would like to convene at 3:30. A couple of us have some,
Convene or terminate?
sorry, not terminate and wait, keep open, because we're going to convene again tomorrow, reconvene tomorrow. So if is it all right with you all if we get through one more, and then Mr. Donahue, I understand, was going to be here tomorrow anyway. if we add him onto the agenda tomorrow?
He was prepared to stay, anticipating
That this might
it be
happen?
necessary.
Okay, so if that's okay with you, I think we will
Very
see
good.
if we can get done around 3:30. Okay, so let's just take a very short break. Yes, everybody convened. Right, we will reconvene at 2:34. I believe we're back to Councilor Albano.
Thank you, Mr. Chairman. I'd like to introduce Jordan Savage, who is the Senior Vice President and General Counsel for Penn National. Mr. Savage.
Good afternoon.
Welcome.
Good afternoon.
Thank you for the opportunity to speak today. I'm Jordan Savage. I am the Senior Vice President and General Counsel of Penn National Gaming. I've worked at Penn National since 2002. I was born in Binghamton, New York, upstate New York. I went to school at the University of Vermont and at Harvard Law School. I started my practice at Wilkie Farr and Gallagher in New York, and I practiced there for 4 years, right up until right shortly before the birth of my first child, when my wife wisely prevailed on me to get a job that gets me home a little more routinely before midnight. We moved to Philadelphia, out to the suburbs, where we've had 3 children who are now 17, 15, and 13. And I worked in a variety of in-house jobs up until 2002, when I took this position, and have worked at Penn National for the last 11 years. Excuse me. I have the primary responsibility for oversight of the legal function at Penn National. We are a department of 6 lawyers, one of whom is primarily focused on property matters, one of whom is primarily focused on litigation and risk management, and then 4 of whom work on transactional and general counseling advice. I also assist our compliance committee in respect to the compliance function. They have, as you know, a chief.
This is the Compliance Committee of the Board.
The compliance committee of the board. They have their own chief compliance officer. It's currently Frank Donahue, who you're going to hear from tomorrow now at this point. And but I attend the meetings and I sit in on the various discussions. I was intimately involved in the hiring of Frank Donahue, which I understand you'd like to talk about. But just generally speaking, word about our compliance group. Frank manages, yet including himself, 5 corporate professionals. And then we have approximately 28 compliance professionals. Each are assigned to a different property. We have kind of a federal system with regard to compliance, where there's oversight and monitoring at the corporate level. And there is an individual person at each property who is responsible for overseeing directly the compliance function at those particular property. They provide weekly reports back to corporate, and all of that is monitored by our compliance staff. The compliance committee meets at least quarterly, more frequently if an issue happens to come up. Of note, we have 2 advisors who are now both independent members of our non-director members of our compliance committee. Steve Ducharme, who we hired very close to when I first started back in 2002. Steve was the former chair of the Nevada Gaming Control Board. He served for 10 years on the board. Before that, he served for 20 years in the Las Vegas Metro Police Department. Since he retired from his board service, he served in various compliance committees at several other well-respected gaming companies. And then we also have Tom Oriyama, who was previously our chief compliance officer and is now a member of our compliance committee. Tom is a 30-year veteran of the, almost 30 years, I think it's 28, of the Division of Gaming Enforcement in New Jersey. He then left and joined Penn National and served us for about 5 years as our chief compliance officer. I think if you don't know them, both Steve and Tom are individuals of exceptional reputation and integrity and knowledge, and they are the company, and mine in particular, 2 principal advisors on compliance matters.
The report, I think, said that there's a 3-person committee of the Compliance Committee of the Board, of which 2 were non-executive board members. I thought it said David Handler and Robert Levy. Oh, no, Robert Levy is
Bob is currently Director Emeritus, and David is also on the Compliance Committee.
And Aremia has taken Levy's place on the committee?
Oriyama is.
Oriyama.
Well, we had 4 when it was Bob, David.
all right.
And then we added, I mean, we have to have at least 3. So
Yeah.
we had, when Tom retired, we went to 4.
Okay.
And now that Bob is Director Emeritus and we're in the midst of this transition relative to the REIT, you know, my expectation is we'll have 1 or 2 more director members by the end of the year. And we'll replace Bob, and David may or may not stay. Maybe he'll after many years of service in the compliance committee, maybe he'll get another assignment.
Okay.
Excuse me. So as you know, we currently operate in 18 jurisdictions. That subjects us to 27 different regulatory agencies oversight. And as Steve mentioned, our compliance function and the licenses that it protects are really, we consider one of our most valuable assets, if not our most valuable asset. Not only because it's what allows us to continue to operate, but it's also our reputation that allows us the opportunity to develop gaming properties in new jurisdictions. And, you know, you've alluded a couple times to, you know, is this a company that asks the hard questions? We do. And it comes out of this compliance function. We take the people that we hire very seriously, and we take our process very seriously. And I'll go through my hiring process, and I'll walk you through the hiring process around Frank in particular, because I think that's what you had asked me to testify on. But this is an issue, having the right people to run the company. I mean, the other most valuable asset of any company is the people who make the company go, right? People, I mean, many companies say people are our most valuable resource, but it's true. I mean, a company is an aggregation of individuals who take capital and do something good with it. And that's the way the game plan's drawn up. And that's what we've tried to do. And I can tell you, when it comes to my hiring, finding the right person is critically important. I learned a lesson before Penn National. I was in a startup, and we didn't have a lot of money. In fact, you know, startup, your biggest financial metric is how much you're spending. You really got to worry about that because you're a little far away from revenue. And I learned a really valuable lesson that every person you hire has got to be an A-plus player. You know, when you're in a startup, you don't have the luxury of having anything less than that. And I hope, and I try, to bring that same mentality to Penn National. I treat every hire like it's going to be my only hire. And I try to go through a really careful, thorough process of vetting that person to make sure that we get the right person from a competence point of view, from an integrity point of view, from a fit point of view, and because you're building a team, and fit's important, and effectiveness point of view. And you need people who are going to be able to accomplish the tasks that you give them. And I think your issue of appearance does play into that. If you have an appearance, if there's an appearance that is so outwardly negative that it prevents somebody from being able to do their job effectively, then that's definitely a negative. And we'd certainly take that into consideration. By the same token, in looking at those criteria, you also want to make sure, I mean, you want people who are of great substance. And my mom gave me a gift when I graduated from law school. It was a quote from the Bible, and it said, "Justice, justice, you shall pursue." And, you know, when looking at people, you know, I try to be fair and I try to be sensible. There's a lot of people that will have a blemish on their record. And the question I ask myself when they have a blemish is not to immediately throw them out, but to try to drill down into the substance and say, is this a person who's going to meet our criteria of integrity and of competence and of fit and of effectiveness? And I can tell you generally, you know, how do I determine that? You know, when I hire, I first assemble a short list of candidates, and I go through. I assemble the list through a whole variety of resources. We use, you know, we start with an internal job. We come up with a job description. We post that internally. Our industry is a pretty small industry. There's a couple dedicated websites which have gotten pretty effective in recent years about getting the word out. Everybody knows what the websites are. People have alerts set for jobs that they like. So we post them on those websites. I push these out through our professional and personal networks. I mean, there's, as you know, you've seen there's many gaming attorneys out there. There's professional associations. You can get the word out in our industry pretty effectively. People, you know, there's, it's a small industry and word travels quickly. So if though all of that fails, then of course we'll hire a recruiting service, and you know, they're oftentimes very effective. Sometimes they're just expensive and not effective. So you want to be judicious in using them. But you know, through all of those different sources, we assemble. We get a pool of resumes, and we, based on the resumes, whittle it down to a short list of candidates. In my hiring process, I then first go through the short list of candidates, and I talk to them either by phone or preferably over breakfast if it's convenient. Sadly, it's not convenient for a lot of people to get to Wyomissing, Pennsylvania. And in fact, it's hard to even get them to Philadelphia sometimes. But I meet them, and I decide in the first instance whether, you know, I think these people merit some further vetting. If I think that they meet our basic criteria, I'll bring them in to meet with a small group, people on my staff and a select others, depending on what the function is. It'd be people that they might be working with. And we'll do this with a number of candidates to get down to a short list. All right, I have to be done by 3:30, right? All right, I'll keep an eye on the time here. All right, I will.
All right,
I will tailor my comments.
Say what needs to be said, it's okay.
So once we identify once we make it through those 2 rounds, I start a vetting process where I check with both the references that the candidates provide as well as independently developed references. And this is really a key source of information. I mean, you know, typically people will give you references of people who are going to say good things about you. But independently developed references, you know, especially in the legal world with all the law firms out there in the gaming world, you know, sometimes you can get certainly the most candid feedback from people. We also have, for candidates who make it that far, we also have, when we whittle down the list a little bit more, we then have an official background checking process. And I think we have an exhibit someplace that goes through all of the different databases that HR checks to make sure that we're not picking up somebody that's got some kind of previous criminal issue, terrorist issue, sexual predator issue. I mean, there are many databases out there that we have access to. But then I personally call the references, especially the independently, when I'm hiring. I call those references myself to check to get the real scoop on somebody to the extent that I can. And if all of this is checking out, I'll then kick it to the other senior managers in the company. You know, sometimes it's Peter, sometimes it's Tim, Bill. It depends on schedules, trying to get people to come out and who's available. But once they get through that whole process, you know, if I can get 1 or 2 or 3 candidates down, then we make a choice. We go through offer and acceptance. Now, that's generally how it works. With regard to Frank in particular, there's yet another layer on top of that. And because he reports directly to the compliance committee, the 2 opinions that were very important to me were my 2 experts, Steve Ducharme and Tom Oriyama. So in addition to that regular process, Frank also met with Tom, and he spoke to Steve. And you know, to I think the issue at hand, you know, to Frank's credit, even though I had known about the grand jury investigation and about the report, Frank was very upfront about the fact that this grand jury report existed, and he wanted to make sure that I had a copy, and I looked at it, which I had. But I was impressed that he brought it up to me. I did read it. I shared it with Steve and Tom, and I discussed it. I wanted to understand, you know, have them give me context about what it was like to set up in you know, generally, what's it like to set up a new gaming board? What's it like, you know, especially in the pressure cooker that was Pennsylvania, where there were timetables set forth, and there were, I mean, it was a unique way to constitute the board. There was a lot going on. Give me a context. Read this and tell me, you know, particularly with regard to Frank Donahue, do you think this is a guy who was doing bad things? Or is there some hindsight going on here in questioning judgments that were reasonable judgments to make under the circumstances? I mean, maybe looking back in 2020, you know, maybe they should have been different judgments, but, you know, help to give me context. And these are two guys whose opinion I respect quite a bit. They've seen and been involved on both sides, on the regulatory side, on the company side, and they really help give me context to it. I talked to Frank directly about some of the issues that were raised in that grand jury report. I discussed his answers with Steve and Tom. And at the end of the day, taking in the full measure of the information we had in Frank, and the grand jury report was part of it. The process that I laid out for you earlier was part of it. We ran through those various steps with Frank. You know, additionally, I had an opportunity, actually with a number of my candidates, I had firsthand experience with their performance. And Frank, when he was on the board side, we were an applicant. And, you know, one of the things that attracted me to Frank in the first place is I had watched him as general counsel and later executive director of the gaming board, and I had a favorable impression of how he handled himself. It was a very under very challenging circumstances. I thought he did a very good job in his capacity there. Additionally, one of the law firms we work with hired him. Afterwards, he ended up doing some work, and I got to see his writing and his legal thinking involved. So, you know, I also had some firsthand experience with how he performed as a lawyer and as a problem solver. So when we took all of this into consideration, and, you know, one of the questions that we asked ourselves is, look, is the information in here, does this make him unsuitable to have this position? You know, does it reflect so severely on his character in light of everything else and putting all the evidence out in front of us? Or, you know, affect his probity, you know, his ability to do this? That we should not make this offer because what's in that report. And at the end of the day, we decided that, you know, based on all of the factors in front of it, that we did not think that the issues that were raised there were so severe as to prevent us from making him an offer. And more importantly, we didn't think that they would prevent future gaming boards. We knew he was going to go up for licensing in some of our gaming jurisdictions as a chief compliance officer. We didn't think that there was going to be a adverse reaction from, or to the extent of denying suitability from those future gaming boards. On the plus side, you know, you look at Frank's resume, we thought that he was going to do a very good job for us. He had a very unique combination of he served as a law clerk to a Supreme Court justice. He worked for 10 years in the AG's office under 3 different attorneys general. That he managed a very large bureaucracy when he was at the AG's office. So that issue about effectiveness, you know, I need lawyers that are also good managers. I have an in-house department, so, you know, we can't just sit and give legal advice. We actually have to make things go, make things happen with that. And it looked like he had some administrative expertise. And I also thought, you know, I had a favorable impression, even though the grand jury report is critical. I had a favorable impression of how he acted in his capacity, his various capacities at the gaming board. So when we put all that together, we made a decision to make Frank an offer, which he accepted, and became our chief compliance officer. Now that was about 2 years ago, and I can tell you that in those 2 years, he's fulfilled our expectations. He's done a very good job. He is a very conscientious chief compliance officer. He gets here early, he leaves late. He really is very focused on doing the right thing. I mean, he gets what his function is at Penn National. You know, he gets that he's got to not just serve Penn National, but he's got to answer to all those different 27 regulatory agencies that we're licensed under. And it's a very important point of pride with him to make sure that he could stand in front of every one of them and explain and justify the things that we do, the decisions that we make. So, and you're gonna have a chance to hear from yourselves. You know, you'll judge for yourselves tomorrow. But that's been my impression of him. And you know, I hope after we're done with this discussion, your discussion with Frank, you're gonna reach the same conclusion.
Mr. Mack?
Okay.
Wait for Mr.
Yep.
Mendes.
All right. Good afternoon, Mr. Savage.
Good afternoon, Mr. Mack.
I want to take just a couple of minutes to ask about Steve Snyder's hire.
Sure.
Because you came on board in September 2002 as
Correct.
general counsel, so
Yep.
you weren't with the company when Penn National brought him on board originally.
Correct.
Or when he left the company temporarily in 2001, I think.
Correct.
But then you were on board as general counsel when Mr. Snyder was hired for the second time in June 2003.
Yes.
Right? Okay. Were you involved in that hire?
In the rehire from a
In the rehire, right? June 2003.
in the compliance. Look, the issue with Steve is, do you rehire a guy who's just settled a serious charge with the SEC? It was a compliance question, right? Is he suitable to be an executive in a gaming company? That was the question. It was really presented to the compliance committee, but you know, I assisted them in that. And you know, you heard from Steve earlier on what the issue was, and it was a complex issue. It came down to differing interpretations of how different interpretations of a rule or a regulation. And you know, we looked at all of this, and you know, our view of it is, you know, we Penn National did not have as much investigatory power as the gaming boards. It was kind of binary. We looked at it. We looked at Steve's explanations, which seemed reasonable. We looked at the charges, which were serious, and you know, we looked at the process that Steve was following to get himself back into the gaming industry, which was he settled his issues with the SEC. He then appeared before a very tough, a very thorough gaming board in New Jersey, and they picked over the issue, I think, quite thoroughly. He also had to pass muster with our other regulators. It wasn't ultimately, you know, in our view, we understood the issue. We understood both sides of it, and we put in place a process that if he got through it, if he passed muster with our regulators, then we were prepared to accept him back because, yeah, he had previously worked for the company. He was known to the company to be a valuable resource. It was known to the company that he was competent, he was effective, that you know, he could do a very important function, which is to help the company find new gaming opportunities. So that's how we approached it.
Let me ask it, I guess, just a
Sorry.
little bit different way. No,
Might have gone off on a
that's very
tangent.
helpful. The New Jersey Gaming Board issued its decision in April 2002.
Yes,
And then you came on board a few months after that.
yes.
Okay. And then when Mr. Snyder went through his employment and hiring process, fair to say you already had on the table the New Jersey decision,
Correct,
deeming him suitable to hold a key employee gaming license.
to my recollection.
Okay. Was, at that point, did Penn National do its own independent assessment of how serious a deal the SEC charges were? Or was it sort of, you know, the New Jersey regulators looked at it, they're comfortable with it, let's move forward?
Look, we didn't have the resources that New Jersey had. We don't have the expertise that they're able to bring to bear. So we did not think that we could do a better job assessing it than they did. We looked at it well enough so that we could understand it. And I think to a point that Chairman Crosby raised, look, you do look at the appearance of it, right? Is this something that is going to create an appearance that is going to so inhibit the ability of the company or the employee that it's going to be a detriment? So we looked enough to understand it, but I can't say that we had the expertise or the resources to evaluate it as well as New Jersey did. We did rely on those investigations.
So just, so to be clear, for example, when you came on board and then Mr. Snyder's hiring process began, nobody asked you to do an independent assessment of how serious the SEC charges were?
No.
Or to go back and read Mr. Snyder's depositions, for example, and
We had our outside counsel, Ballard Spar, was looking at that.
okay, so you did have Ballard Spar take an independent look at it.
We
then,
did.
Second time around. Okay. Is a general matter, and I suppose this relates to Mr. Snyder, but maybe others as well. If you have a state regulatory body like the New Jersey Commission assess a key gaming employee as suitable, then from your perspective as the employer, would that typically be a decision you would follow, or would you do your own independent review?
I mean, typically our review is going to go more to competency, right? Is this
Right.
person going to be an effective employee? On the issues of suitability, we have some capabilities, obviously. I mean, we have our own resources. We can hire investigators. But if there's an opportunity for an agency with police power to do an investigation, we consider that a better indication of suitability than we can muster.
Okay, so competency aside, and I get that because as the employer, you're the expert there, but with respect to suitability, you would tend to follow the outcome reached by the regulatory agency with jurisdiction over that suitability determination.
Yes.
Now, by the time Mr. Snyder came on board, the compliance committee was up and running. And actually, it might be helpful if you can refer to the compliance plan, which is your applicant exhibit 2. And in particular, I want to go to page 10, it's section 5.5.3.
Yes.
I take it that Mr. Snyder is the senior vice president in charge of development. He would be an executive officer in that
He was
capacity,
not.
right?
No.
Oh, okay. So,
He wasn't at the time. He has since become one, but.
okay, but was not then.
The head of development is not necessarily an executive officer. in the
Okay.
FCC rules.
Because it says here, the second sentence says, company investigations regarding the suitability of prospective directors, executive officers, and key gaming employees shall be reviewed by the compliance committee. But he would not be in that category of mandatory review
He wasn't.
at that time.
At that
Okay.
time.
But it said key gaming employee. Wouldn't he be a key gaming employee?
I don't believe he was at the time. In a lot of states did not require the head of development. It's my recollection now, you're asking me to go back 10 years, but I don't think he subjected himself to licensing for his own particular issue, but I don't recall that he had that status at the beginning. It was something he's earned over time. His company's grown.
I'm not sure where Mr. Mackey's, going on this, but key gaming employee in the policy is defined as means any executive or employee of the company having a material involvement in the gaming business of the company and who has a base salary exceeding $90,000 per year.
I'm not sure if that was our touchdown back in 2001. I'd have to go back and look.
The
But
next.
at
the-
any rate, you know, given Steve's issues, we did look at it.
Okay, well, I guess that was my next
Yeah.
question, because the next sentence is the suitability of any company employee. So that could be, you know, literally somebody who's dealing cards, I guess, may be reviewed by the compliance committee. And it's your testimony that Mr. Snyder's hire in 2003 was in fact reviewed by the compliance committee.
I recall discussing with Ducharme whether it was formally reviewed or not. I cannot recall. In a formal committee setting?
Mr. Ducharme, again, was the chair of that committee.
Yes.
So, okay, so you don't recall whether it was formally reviewed by the compliance committee? Okay. If you could turn, Mr. Savage, to page 282 of the suitability report. And, are you there? The top of page 282, there's a summary of a discussion that you had with the investigators. And there's a couple of sentences at the top of that paragraph about your familiarity with the grand jury investigation that you were referencing in your direct presentation.
Right?
It says, well, the second sentence, Savage stated that he was familiar with the grand jury investigation and that he had read the report. He does not recall details, but he believes he probably discussed the report with other Penn National officers, but only in general terms. Did I read that correctly?
You did.
Okay, is that a fair summary of what your
It is.
discussions with the investigators was?
When I looked at, yeah. Yeah, when I looked at the grand jury report, I discussed it with Tom and with Steve. I considered it a compliance issue. You know, I did not, those issues of competency and effectiveness, those are the issues that I discussed with the other officers, with Peter and Tim. Hey, is this guy going to be good for us? Is he going to do a good job? Does he have the right characteristics? This issue, which I considered a potential compliance issue, I discussed with the guys that I had expertise there to see if does this rise to a level that's going to create a concern.
Okay.
And ultimately, it was the compliance committee's call.
Right. And you're talking about with respect to Mr. Donahue's hire?
Yes.
Okay. So the discussions that you were referencing here in the report, I guess what I'm trying to get at, was the issuance of the grand jury report, was that a subject of general interest and concern at Penn National, or really more an issue as regards the hiring of Mr. Donahue and how it might relate to that issue?
It was an issue with regard to Mr. Donahue.
Okay. Now, if I could draw your attention to Bureau Exhibit 10, which is a copy of the grand jury report. And you acknowledged to the investigators that you'd read the report.
I did.
Okay. And that you might have discussed it with others at Penn National. That it was your general recollection, it sounds like, that you had discussed it.
Yeah, with Tom and Steve.
Okay. Now, would you acknowledge, Mr. Savage, that it would be fair to say the report was harshly critical of the Pennsylvania Gaming Control Board? Would that be a fair statement?
I think that's a fair statement.
Okay. And that, in fact, it reserved some of its harsher criticism for the board's prosecution of these suitability investigations. Would that be fair?
Seem to, yes.
Okay. And that among the suitability investigations that got a fair amount of play in the grand jury report was the one related to Mount Airy #1?
Yes.
Which was the entity owned by
Right, I
Lewis
think the two,
Naples.
it was Mount Airy and the other was probably the Barden. I think it was the Barden deal.
Yeah, that sounds right. But one of the ones that they focused on was the Mount Airy.
One of them,
Is
yeah.
it Lewis to Naples or Louis to Naples?
I don't know.
Okay. And it would be fair to say that the grand jury report reflects that Mr. Donahue had a prominent role in the crafting of the final suitability report related to Mount Airy.
May I object? My grounds are, I don't believe that is a fair. So,
Okay, well, let's look at the report then. I'll go through it and we'll read some of it into the record. Page 64 of the report. Okay, just down at the bottom of the page. That last paragraph beginning on that page, Greenbank described. Do you see that?
Yes,
Okay, do you know who Mr. Greenbank is?
I do not.
Okay. Greenbank was an investigator with the Bureau at Pennsylvania Gaming Control Board. And he describes a meeting that occurred just weeks prior to the award of the license. And this is again in the context of the Mount Airy piece. And it says, the agents assigned to investigate Mount Airy, Davenport, Schroyer, Neeb, Donahue, Miskin, and the Director of Diversity were all present. Do you see that sentence?
I do.
Did I read that correctly?
I wasn't following.
Okay, I did, take it from me. I read it correctly. Accept it as true that the Donahue reference there is the Frank Donahue that
believe
is will be
that's
tested. Okay. Now, on the next page, there's a sentence, the second full sentence, beginning with Greenbank described. The outcome of that meeting as follows. The sum and substance of that meeting, which was long, I would say a couple hours, was this. And this was a joint agreement by Ann Neeb and Frank Donahue that you have more than enough evidence here to deny him, and that's Louis DeNaples, a license based on Katrina and Ram alone. You have proof. Don't put anything else in the report to water it down. Don't put anything in the report that cannot be substantiated and cannot be proven. Do you see that?
I do.
Okay. I read that correctly?
You did read that correctly.
Okay.
I followed this
And then
one.
the next full paragraph, I'll skip a little bit here, but then at 11 a.m. on December 1st, 2006, the date that Mount Airy's suitability report was due, Davenport met with Neeb and Donahue. By the way, do you know who Neeb is?
I do know Andy.
Okay, she was the
First
executive director.
director.
First executive director of the board. Davenport met with Neeb and Donahue. During that meeting, Neeb and Donahue required Davenport to make changes to what she believed was her final honesty, character, and integrity report on Louis DeNaples. Did I read that correctly?
Yes.
Okay. Would you agree with me that it would be fair to say that Mr. Donahue had a prominent role in the editing of the final report, at least as reflected in the grand jury report here?
Yeah, I don't know about prominent. You know, I don't know what, a lot went into preparing this report. As I understand these reports, they were prepared at length through BIE and then presented to Donahue and Neeb at the end. So I acknowledge that this says what it says.
Okay. Yeah, I don't, there's no sense in quibbling about the language. The grand jury report, you'd agree with me, reflects that the executive director and Mr. Donahue either required or ordered certain changes to be made.
Yes.
Okay, thank you. You testified in your direct presentation that your review of the grand jury report, report itself, it sounds like it got some fairly prominent attention from you and the head of your compliance committee and maybe others at Penn National in connection with Mr. Donahue's hire.
Yeah, from me and from Tom Moriyama, who was our chief compliance officer at the time and was helping me vet the candidates for his successor.
Okay. Just back to the suitability report for a second. Page 282. last sentence, first paragraph. While he, are you there?
Not yet.
Okay. Last sentence, first paragraph. While he, and the he is you here, while he did discuss the grand jury investigation with Donahue, he did not place any significance on the grand jury report during Donahue's hiring process. Is that a fair summary of your statement to the investigator?
I didn't think so.
You don't think that that sentence
Look,
accurately reflects
I think
what you
we-
said to the investigators?
No, I thought, what I think is accurate to say is at the end of the day, we didn't attach a lot of significance to this in terms of the overall evaluation. Obviously, we went and hired him. So this was one piece of a puzzle, and we thought we had a lot of good information about Frank Donahue, of which this was a piece of it. That's not to say that we didn't do the work in understanding what was in here and coming to a conclusion about it.
Okay, so okay. Did you ever discuss the issue of the grand jury report as it affected Mr. Donahue's hiring with Mr. Carlino?
I mentioned it to him.
Okay, what was that discussion?
I mentioned that he was in the grand jury report, that we had looked at it, that Tom and I had looked at it, discussed it with Steve, that we didn't think it was going to adversely impact his suitability, and that it had been vetted by the right processes, by the right people in the company.
Did Mr. Carlino have a reaction to that?
No, I think he relies on us to make those determinations. But, I need that. It was significant enough that I wanted to point it out to him.
And in substance, is that what he said? I'm going to rely on you guys to make the right call here.
In substance.
Okay. How about Mr. Wilmot?
Could I just interrupt? On page 281, talking about the interview with Mr. Carlino, it says, he stated that the investigation was discussed with other officers. This is Mr. Carlino speak. He stated that the investigation was discussed with other officers of Penn National in general terms, but that he did not place any serious significance on the investigation or the report because he did not have confidence that the proceedings, the grand jury proceedings, would result in an accurate reflection of the operations of PGCB.
You'll have a chance to ask Peter, but look, I think there was a general belief, and that this is my focus on Frank. I mean, there's a couple. This is a long. The grand jury report's on 122 pages. There's a few pieces on Frank. There is a much larger report there, and it was, I think, to Mr. Mackey's original point, it was very harsh, and. There was, I did also believe, and I think I mentioned this to the investigators at the time of the interview, having been an applicant in front of the Pennsylvania Gaming Control Board and watched the process unfold, I did think there was a bit of a disconnect between what I was reading in that grand jury report, which paints a very bleak picture of what was going on with what I observed. I had the chance to interact with a lot of staff at the Pennsylvania Gaming Control Board. We were called in front to do a licensing hearing similar to this one. I thought they did a very good job. And I think it's generally believed that they did a very good job in getting gaming off the ground in Pennsylvania. I mean, this report only focuses on 3 of 15 applicants. So, probably, Peter's comment is, you looked at, the grand jury looked at, these particular elements, and certainly focused on the things that they had a problem with. But when you look at the body of work, I think all of our view at the time is that the Pennsylvania Gaming Control Board did a very good job under difficult circumstances. They were thorough. I know, look, I have, I don't know, the privilege or the pain of being investigated, and personally and as a company by all these 27 regulatory agencies. So we do have kind of an interesting perspective of comparing and contrasting, and it did appear to us generally, I mean, to me, and I suspect Peter meant the same thing, that it didn't really reflect their full body of work. But you'd have to ask him directly on what he was thinking. It's just my speculation.
How about Mr. Wilmot? Did you discuss the report with him?
I don't recall which other officers I may have mentioned it to. I report directly to Peter, as does Tim. So before, when I was briefing Peter that I was going to make a recommendation to the compliance committee, that Frank was the guy, I gave him the good, the bad, and the ugly, as I would with any candidate. I don't do that with the other officers.
Okay. What about the compliance committee then? Would this have been one of those hires that unlike Mr. Snyder's, would have had to go through the compliance committee?
It would have,
It would have.
absolutely.
Okay. So could you describe to me what that process was? Is that something that do you sponsor the potential employee in front of the compliance committee, make a presentation, or how does that work?
No, it's not formal. The committee meets quarterly, and in a hire such as this, I think, especially with Tom, who was we had a chief compliance officer, he interacts primarily with the committee. He and I were cooperating on hiring a successor for him. I think each of us spoke to Steve Ducharme, who's the chairman of the committee, and then Tom or Steve would talk to the other members. The director members would typically rely on Steve and Tom in making a decision of this sort to come to a consensus.
Okay. So there wasn't a specific meeting at which this was an agenda item for deliberation amongst the committee?
I don't recall there being one.
Okay.
It may have come up, but I don't recall.
Excuse me, in our report and in Mr. Donahue's testimony, there's no mention of Steve Ducharme as having been involved. It refers to Oriema.
Well, I did speak to Steve.
You did not?
I did.
Oh, you did?
On Frank.
Okay, you didn't mention that to the investigators, or if you did, it didn't get picked up. Okay.
That may not have come up.
And Donahue didn't know that you did because he thought it was only you and Oriema that had discussed it. Okay.
Do you know, Mr. Savage, did you give to Mr. Ducharme or any other member of the compliance committee a copy of the grand jury report?
I did.
Okay.
To Steve.
To Steve, okay. And do you know if he read it?
I believe he did.
Okay. Did you ever have a discussion with Mr. Ducharme about the contents of the report?
I did.
Okay. And can you describe for the commissioners what that discussion was?
Look, it was, as I mentioned in my testimony, I wanted to bounce it off both Steve and Tom to get their reaction to it. Here's a guy we're hiring who's mentioned in this grand jury report. We were making our own suitability evaluation. Are the issues that were raised here, do they rise to the level where we would find him not suitable to hold this position?
Okay. And was there anybody on the compliance committee, Mr. Ducharme or other members of the committee, other members of the board who raised a serious issue about the hiring of Mr. Donahue in light of the report? In words or substance, great guy, very qualified, but let's step back because this looks like a serious issue. That kind of thing.
Well, I think the fact that we discussed it, I mean, this in what is otherwise an exemplary career, and a person who made a very positive impression. We had this one data point in the grand jury investigation. The question is, does this one data point rise to the level of, does this negate everything else that we found out about him? So we had that discussion. I mean, I think that's the hard question. You got to look at this report and say, gee, do I not hire this guy as a result of what's in here? Mm-hmm. And I think one of the points in particular on this page you had me look at that I recall is, the issue here was not whether whether there was going to be a negative or positive recommendation about Louis de Naples. I'm going to go with Louis, Mr. Mackey. I'm not sure that that's right. Okay. They were on board with a negative recommendation. That the issue here seemed to me, anyway, to be one is how best do we present the evidence in this case? They had two issues that they felt very bullish on that were slam dunk, couldn't be challenged type issues about these retitling of Katrina trucks and the political contributions from RAM. There were other issues that they felt were unsubstantiated, that they didn't have the right evidence. To me, this is a kind of discussion that happens among lawyers before they present a brief. I've got 4 arguments. I've got 2 that are really strong. I got 2 that are so-so. Do I just go with the 2 that are really strong? Do I put the 2 that are in there that, you know, the weaker ones, is that going to undermine my credibility? Is this going to be challenged in the future? I mean, that's how I interpreted this. To me, this did not rise to the level of, and especially after getting context and talking to Steve and Tom about how these decisions were made, it didn't rise to the level of being like an alarming suitability issue. It's my interpretation.
He was wrong in that judgment, that he had 2 slam dunk points and the other ones would weaken the, in fact, the board did not, I did find Mr. DeNaples suitable.
Indeed, that is what happened. I agree, but in looking at the process, you know, look, it would have been a different picture if this grand jury came back and said, you know, he was trying to influence this into a positive recommendation. I mean, I think it's clear in another place in the report that they were on board with a negative recommendation. This is a judgment that got made about how best to present evidence, and I think every lawyer probably looks back at some case or another in their life and say, gee, I wish I had made that argument differently.
It is more than that. I mean, there is strong evidence that he demanded, contrary to the wish of the investigators, that this information be taken out, and that under duress, there's a debate about this, but the allegation and testimony is that under duress, his subordinates took it out because they had been told to take it out by him.
I understand, but I think, look, it was my estimation in talking to my advisors that it was with a view towards trying to get to the right result. It may have been the wrong call, I grant you that, Mr. Chairman, but you know, to me, what was important was the intent, at least as best as I could read it from the grand jury report.
Just a couple more questions. You described this as a decision that lawyers get together and they make every day in terms of, you know, how to present evidence, how to present the case. And it would be fair to say that the commission, or the board, I guess as it's called in Pennsylvania, the board was Mr. Donahue's client, correct? The board members, the board was his client.
It's a technical question, but I think probably, without getting into tech, I believe
Because
that's probably a fair statement.
Looked at through that lens, there is a strong case to be made that this was not so much about presenting evidence in a way that was likely to prevail, but disclosing important information to your client so that they could make whatever responsible decision they needed to make.
I don't think that's the way they felt. I think they generally have a, you know, and I checked in the vetting process, they generally had a very positive impression of Mr. Donahue.
The board.
The board. Yeah.
No further questions.
I have a couple questions for you,
Please.
sir. My concern in reading this is not necessarily the outcome of the hire, but the process.
Right.
And, you know, you say you spoke to Mr. Donahue and you spoke to your compliance people. My question to you, did you speak to anyone else involved with that report, whether it be investigators, whether it be attorneys, deputies, attorney general that were involved with the process? I mean, just reading a report and making a decision after speaking to the individual doesn't seem to me that that's a lot of due diligence over a very serious issue.
No, you know, I knew we had, as part of Frank's hiring process, he was going to be submitting licensing applications. There's going to be further review. But, you know, there's a limit to, you know, like I said, our investigatory powers. I don't really feel like I have the ability to call up investigators who I don't know and, you know, start taking testimony myself.
Not testimony, but just trying to understand from the perspective of those who were there firsthand about what exactly happened here. Something that's of concern to me is not as much the unsubstantiated information, but the fact that investigators were not allowed to try to substantiate information. That's very significant in my mind in reading this. So I just, when you say you place no, in one, page 37, you say you place little credence, and later on you said you pled no credence. And it just strikes me that you did realize how significant this
Yes.
was, and you know, there is a body of work beyond this, which you do recognize, which is appropriate to recognize. But the fact that you place no significance at all, and that the only conversations you had are with your own internal compliance people and with the individual who you're potentially going to hire, that's
Well,
what
it
strikes
also,
me
look,
reading this.
no, I mean, there's another element to it. When I checked the references, well, I didn't discuss the grand jury report specifically. I did speak to people who are very familiar with Frank's work, and I did ask generally about the quality of his work and his integrity and his commitment. I didn't drill down on these specific facts. I thought that was a fair diligence process in terms of making an evaluation about his competency and his integrity, talking to people who are there who are familiar with his work, talking to people who I know to be experts on regulatory matters. I thought it was sufficient.
Others?
Just a couple. You've
Sure.
a couple of times said, used the phrase, the issues that were there in the context of your hiring process. You said on one occasion that I didn't think that the issues that were there would keep Mr. Donahue from doing a good job as chief compliance officer.
Mhm.
What were those issues?
The issues raised in the grand jury report.
What were they specifically as you think through them now? I mean,
Look-
what, I guess I'm asking, what issues did the grand jury report raise for you?
In my mind, I mean, the issues were about the judgments that were made about how to fashion these reports to the board, about whether, what evidence to include and how substantiated it needed to be.
And so that's really, is there more than one issue there? I don't want to break it
No,
apart. I'm just
I-
trying to figure out what you took away from your reading.
That was primarily
Okay.
what I took away. I mean,
So
it's
did you
been
ask-
a while since I've looked at it, but
It's been a while since you looked at it?
since I looked at this issue in his hiring, that was 2 years ago.
In getting ready for today's hearing, did you look at it?
I did.
So you looked at it within the last couple of days?
I did.
Okay. And so did you ask Mr. Donahue about that issue, as you've just framed it,
Recently or originally?
originally during the course of the hiring?
Yes, I did.
And what did he tell you?
He told me that he was worried about a principle in Pennsylvania administrative law about having substantial evidence to back up the claim. He was worried about back up the issues that they presented in the report, that he was worried about this being subject to a future litigation and wanted to make sure that they put before the board evidence that would withstand later scrutiny, judicial scrutiny.
And you're familiar with the substantial evidence principle, are you?
I am not an
law
administrative law expert.
And did he explain to you anything more about the issue then? Than that he was worried about substantial evidence?
I mean, to my recollection, that was generally the issue.
Okay.
And I don't know if I'm missing a nuance that you're asking me about.
No, I guess
but
I'm asking the question I'm not really interested in the answer to, and I apologize for that.
It's okay.
Did you because the real question is, how deeply did you think you had to probe his rationale for doing what the grand jury described he was doing?
I thought it was sufficient for me to speak to people who are more expert on this matter than I am, to get their response, to get their evaluation of what's contained in this report. I mean, I read it and I made my own evaluation, but I'm not an expert. I'm smart enough to know that when I'm not an expert, I should seek the advice of those who are.
And you said at one point during your testimony here today that appearances are important if and to the extent they prevent somebody from being effective in doing their job.
I did say
and
that.
I take it you formed a judgment that the appearances emanating from this grand jury report would not be significant enough to prevent Mr. Donahue from doing his job.
I did at the time.
And could you give us your thought process there?
I thought that this issue, when you look at when he came up for later evaluation, and particularly in the context of a suitability hearing where his entire background will be evaluated from age 18 until the present. I really did come to the conclusion that this would be just one small issue in what is, as I think I mentioned before, a very exemplary body of work. I did not think that a gaming commission would look at only this and nothing else, and not the rest of his record, and say, this by and of itself is going to make him unsuitable. I mean, I could be wrong. You may come to a different conclusion, but that was my estimation at the time, and I discussed that with Steve and Tom, and they agreed. I mean, we just did not think that what was in here was a fatal flaw.
There's external external effectiveness, i.e. the effectiveness of his relationship to the outside world, specifically gaming commissions and
Absolutely.
licensing, right?
Absolutely.
But there's also internal effectiveness. Did you think about how this might affect his internal effectiveness, his ability to be an effective compliance officer internally?
I did not think that this would impact his ability to be effective internally.
Why?
Because the other traits that I had come in my interview process, the other traits that I believed he had are what were going to drive him to be effective. He has, I think, very strong interpersonal skills. I think he's even-keeled. He's experienced. He's run administrative agencies before. He understands, he's had experience, especially with an emerging gaming jurisdiction, which is, as we are here, and that's a lot of where our new business development comes from. He had the right level of experience, the right level of character and characteristics that led me to believe that he would be a good fit for us internally. And that he would be, look, it's important for a compliance officer to work effectively with the other members of the team. He's got to be able to get a free flow of information from everybody. He needs to be trusted. And I thought Frank possessed those attributes.
Did you think that that appearances, and we've talked a lot about appearances today, and this is the tack that I'm on now.
Yeah.
Did you think that any appearances flowing from the report might interfere with his ability to get information, to lead, to act as an example of the kind of compliance that you wanted Penn National to have?
I did not at the time, and I have seen nothing over the last 2 years to suggest to me that it has.
Thank you.
Anybody else? Commissioner?
I noticed some of the officers of Penn are licensed in Pennsylvania.
Yes.
Do you know when that may have been when maybe that took place? Approximately.
I would imagine that that occurred in the 2007.
And I also noticed that Mr. Donahue is not licensed in Pennsylvania. Is there a particular reason for that context, or?
It's, it's up to each state's regulator. Oh, he is licensed.
He's licensed.
Thank you. Yeah, it's up to each
That's
state,
right.
we
Sorry.
take our,
That's
look, we take our key from each of the states, from each of our regulatory bodies as to who they want us to call forward for licensing. Each state's a little bit different.
Thank you.
Commissioner?
Quick question.
Sure.
As you were considering his employment, any interaction with your senior VP of Human Resources? Somebody who's charged with recruitment and training of employees, or does that individual not play a role with executive recruitment or executive hiring?
He does play a role. He does play a role where requested. When I hire professionals, I typically are typically not using HR for that function, although they did meet with him. They do the assessments, they do the background checks. So I don't know if he actually met with Gene. I'm fairly certain he met with someone on Gene's staff at the time.
But you talked about, raising this issue with Tom and Steve Ducharme. Did you ever have a conversation with your VP of HR about the issue? Or
I wouldn't typically on a compliance issue, which I consider this to be a compliance issue. I would go to my experts on compliance.
Did it? In Mr. Donahue's January 18th, 2012, it's our Exhibit 11 testimony. He says the following: "The Deputy Attorney General also asked me questions about the performance of the BIE attorney who represented the board at the DeNaples suitability hearing. The Deputy Attorney General asserted that a number of grand jury witnesses who had testified prior to me were critical of the manner in which this BIE attorney had handled the matter. I testified that, as an attorney, I was not going to be critical of another attorney's job performance." How does that strike you?
I'm sorry, I didn't follow. Which one is it?
It's the third page of our
Exhibit 11?
Exhibit 11.
Okay.
The middle paragraph, it starts out the Deputy Attorney General.
And who is the Deputy Attorney General in this case?
That's the Deputy Attorney General who's running this is during the grand jury testimony. So the
Okay.
Deputy Attorney General is asking Donahue that question.
I'm not sure I understand this comment.
That makes two of us. Well, I mean, the reason that I ask it, it goes it seems crazy to me. He was the boss. This attorney worked for him. He was the general counsel, and he's telling the Deputy Attorney General in a grand jury investigation that he would not be critical of another attorney's job description. I'll ask this of him, obviously,
Yeah,
but it makes you
I'm sorry.
wonder, what kind of a compliance officer are you going to have if he's not willing to ask to be critical of another attorney? And that goes to the question about what, you said there was this sort of isolated incident in a great body of work. And I'm looking for cues as to this man's character in the compliance job. You don't have any more sensitive job in your whole organization
I agree.
than your chief compliance officer. Not a happy place to be lots of time for somebody with a real character of steel. And that
I
doesn't
agree.
sound to me like somebody with a character of steel.
Look, I can't comment on the context here, but I will add that, in the 2 years that I've watched him perform, as he's assisted individuals with various issues that have come up, I have watched him ask the hard question and, and give the hard answer even when his recipient doesn't really want to hear that answer. So I can only go by my own experiences.
I will say what I had said in two other instances. To me, it's just astonishing that nobody would have said, hey, maybe he's a really good guy, but we don't need this. You know, this just doesn't make sense. There's just a disconnect. We're not going to, nobody knows for sure what's behind this. It smells. Everybody was talking about it. We were up here in Massachusetts, knew all about it, and you guys were in Pennsylvania. And it's just amazing to me that nobody said, this doesn't make any sense. You know, why would we want to hire a guy who's under a cloud like this to be our chief compliance officer?
You know, I think we did, Chairman. You know, we did consider this issue. And, you know, I feel that it's, you know, in trying to look past it, we tried to get to what the substance of the man is. That's, at least in my process, that's what I feel I do with each of our candidates. And, you know, I think it's unfair and it's a loss to the company if you take something that, if you take an appearance and you don't drill down into you don't come to a conclusion about the substance of the person. I mean, you can miss out on somebody really good. And I agree, appearances do matter, but the substance also matters. And, you know, I hope if you draw from this, I mean, I see where, you know, you're obviously making very clear what your concern with us, that there is, you know, that these appearances aren't taken into account. But, you know, there's a flip side to it where we also take the time, we think, to look in the substance of the person and not to throw somebody out just because there might be a superficial question or even a significant question if we have good reasons and good substance behind that to make a decision to hire somebody.
Anybody else? Anything? Anybody?
No, nothing. Thank you. Thank you very much.
Thank you. We will not adjourn. We will just temporarily adjourn, I guess, or whatever the word is. Recess, thank you. And so we won't do a closing statement until after your other witnesses. And our plan, I believe, our hope is to convene at 1, right, tomorrow. We will be here in the morning having our regular meeting, and then we will reconvene this at 1 o'clock tomorrow afternoon.
Very good.
Thank you.
Thank you.
Thank you.
Mr. Chairman. Thank you, Commissioner.